Codicil. A codicil is a supplementary document used to correct, amend, alter, or revoke an existing will. All the principles applicable to the making of a valid will applies to the making of a codicil. Very important, there can be a will without a codicil, but there can never be a codicil without a will. Functions of a codicil. 1. It may affirm the contents of a will. 2. It may alter or amend the provisions of a will. 3. It can be used to correct a clerical error in a will. 4. It may revoke a will. 5. It may republish a will. Similarities between a will and a codicil. 1. Both of them are testamentary. 2. The both of them are ambulatory. 3. Both of them are revocable. 4. The both of them are dispository. Differences between a will and a codicil. 1. A will comes first and a codicil comes last. 2. A will is independent, but a codicil cannot stand on its own. Very important. 1. An unclear codicil is invalid and of no effect. A codicil which is unclear or equivocal will be declared void by the court for its uncertainty. 2. However, misdescription of codicil does not make the codicil invalid, nor will it be invalid because it failed to recite the exact date on the will. 3. In constructing a will containing an ambiguity, a court may refer to a recital in a codicil to clarify and explain the content of the will. When to advise a client to execute a fresh will. 1. Where there is a new or subsequent marriage. 2. When there is excess alteration or mutilation of the original will. 3. When there is change in finances and assets. 4. When there is a change in residence. Ethical issues. 1. A lawyer should know when to advise a client to prepare a fresh will. Rule 16 of the Rules of Professional Conduct. 2. A lawyer should also know when to advise a client on the necessary conditions or factors that could lead to the failure of a gift. 3. A lawyer owes his client a duty of confidentiality. To this effect, a solicitor should ensure that he does not divulge the content of a will. Rule 19 of the Rules of Professional Conduct. 4. A lawyer owes a duty of non-disclosure of conflicting interests to his client. Rule 17 of the Rules of Professional Conduct. Restrictions on testamentary freedom. Under the Wills Act, a testator can freely dispose of his properties and make his will without any form of hindrance prescribed by statute, custom, or religion. In the case of Banks and Goodfellows, 1870, IR 5 QB 549, the court affirmed the right of testamentary freedom of a person. It held that a person at all times has the right to make a will and give his properties to any person he desires and wishes, and may also deprive any of his blood relatives of his properties without any questions being asked. However, over time, it was felt that this absolute right to dispose of properties to any beneficiary occasioned hardships on the relatives of the testator to freely dispose of his estate. The restrictions include the following. Reasonable financial provisions to the defendant. Section 2 of the Wills Law of Lagos State provides that where a person dies and is survived by any of the following persons: A. The wife or husband of the deceased, and B. A child of the deceased, that person may apply to the court for an order on the ground that disposition of the deceased estate affected by his will is not such to make reasonable financial provision for the applicant. Reasonable financial provision for a wife, husband, or child is such as would be reasonable in the circumstances for that part to receive, whether that provision is required for his maintenance or not. Contrast this to the position in Kaduna, Abia, and Oyo State, where the persons who can apply for reasonable financial provisions include the parent, brother, or sister of the deceased, who immediately before the death of the deceased was being taken care of either wholly or partly by the deceased. Section 27 of the Kaduna State Wills Law, Section 4 of the Abia State Wills Law, and Section 4 of the Oyo State Wills Law. The application must be made within 6 months from the date of the grant of the probate. Very important, this application may only be made where the will of the testator had failed to make reasonable financial provision for the applicant. There is the need to delimit the meaning of child, brother, or sister, because in Nigeria this may have extensive meanings to cover those that may not be related by blood to the testator. The test for determining reasonable financial provisions is objective and from the point of view of the court and not subjective from the point of view of the deceased. In Recoventry EWCA CIV JO 718-3, the court held that the provision is not intended to keep the applicant above the breadline, but such as to maintain him in a manner suitable to those circumstances. The court has the discretion to extend the time which the application can be made if 1. The discretion is exercised judicially, 2. The applicant establishes substantial reasons for the success of the application, 3. The promptness of submitting the application, 4. Whether a negotiation to settle the problem was held within time, 5. Whether the estate had been distributed before the application was made, 6. Whether refusal to extend the time will leave the applicant without any option. Customary law restriction. Section 1 of the Wills Law of Lagos State provides as follows. It shall be lawful for every person to bequeath or dispose of by his will executed in accordance with the provisions of the law all property to which he is entitled, either in law or in equity, at the time of his death, provided that the provisions of this law shall not apply to any property which the testator had no power to dispose of by will or otherwise under customary law to which he was subject. Very important, Abia State does not have the customary law restriction or the Islamic law restriction. The testator enjoys total and complete freedom to dispose of his properties. In Idehe and Idehe 1991 6 Nigerian Weekly Law Report, Part 198382, where the testator gifted the Igyobe, the house in which the testator lived and died, to one of the wives of the deceased testator rather than to his eldest surviving son. The question that arose thus was whether the phrase "subject to any customary law restriction thereto" occurring in Section 3 sub 1 of the Wills Law of Bendel State is a qualification of the testator's capacity to make a will or qualification of the subject matter of the property disposed. Under the Benin native land custom, the eldest surviving son of the deceased inherits the house known as the Igyobe. It was held that the gift of the Igyobe to the wife was invalid based on the restriction which the Benin customary law attaches to it. The restriction is that it must go to the eldest surviving son of the deceased. The opening words of Section 3 sub 1 of the Wills Law are intended to relate to the subject matter of the device. The case of Lawal Osula and Lawal Osula 1995 9 Nigerian Weekly Law Report is also instructive in this regard. In Asika and Atwaya 14 Nigerian Weekly Law Report, Part 1375, page 510, the will of the testator read thus: I give and bequeath in equal shares unto my children, namely Paulina, Michael, Fidelis, Catherine, Cordelia, and Felicia, all my possessions. The plaintiffs who married women who were daughters of the testator claimed against the defendant, who is his son to their brother, for a declaration that they were entitled to equal shares of the testator's estate. The defendant contended that under the Onitsha native law and custom, the plaintiffs were entitled to inherit only the property of their husbands and not of their father. The Court of Appeal held that the Constitution of the Federal Republic of Nigeria grants women and citizens the right not to be discriminated against and the right to acquire immovable property in Nigeria. Thus, the proposition of the respondent relating to the sharing of the estate in accordance with the Onitsha customary law cannot prevail over the provisions of the will. Islamic law restriction. Religion may also restrict the right of a testator to dispose of his estate in a way and manner he deems fit. In Adesubukon and Yunusa 1971 1 all NLR 225, the testator was from Lagos State and was subject to Islamic law of the Maliki school. He made his will according to the Wills Act. The will was challenged for not making certain dispositions to the heir of the testator. The trial court held that the testator, in accordance with Islamic law, cannot dispose of more than 1/3 of his property to persons who are not his heirs, and that the Wills Act cannot override the provisions of Islamic law on inheritance. The Supreme Court reversed the judgment and held that since the testator intended to distribute his estate according to the provisions of the Wills Act, the Act prevailed over any native law and custom which applied to the testator. Very important, the restriction contained in Section 2 of the Wills Law of Kaduna State may be summarized as follows. Every person is guaranteed the right to dispose of his properties by will. This right does not apply to the will of a person who immediately before his death was subject to Islamic law. The restriction does not apply only to property, but applies to persons who are also subject to Islamic law. This may raise the question, is there any distinction between a person subject to Islamic law and a Muslim? In Ajibaye and Ajibaye 2001 All Federation Weekly Report, Part 359-1321, the deceased testator Alhaji Disu Ajibaye, a Muslim from Ilorin, made a will under the Wills Act and disposed his estate not in consonance with Islamic law. He stated in the will, I also direct and want my estate to be shared in accordance with the English law, and having chosen English law to guide my transaction and affairs in my lifetime, notwithstanding the fact that I am a Muslim. The court held that the will in the dispute is void ab initio for being contrary to the Wills Law of Kwara State, which was in force at the time. He therefore could not validly make a will under the Wills Act. The properties of a non-Nigerian Muslim are subject to the dictates of Islamic law of inheritance, which does not allow disposition of properties anyhow. Having declared that he was a Muslim, the testator had subjected himself to the application of the Wills Law of Kwara State, notwithstanding his erroneous belief that he could elect to be governed by the English law while he was still a Muslim. Advantages of a solicitor drafting a will. 1. The solicitor, being presumed to be very knowledgeable in law, will comply with the requirements of the provisions of the law with regards to the drafting of a will while he is drafting. 2. The skills possessed by the solicitor will be employed to prepare a good will, which of course will reflect the client's instructions. 3. The solicitor is likely to be reliable enough to keep custody of the will and to produce it in the event of the death of the testator. 4. Solicitors have been found to be very useful witnesses in the event of any dispute to prove due execution of a will. Adebajo and Adebajo. Quick glance note is powered by Rollums and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Conic Close of Idemai Crescent, Igbefon, Lekki, Lagos, Nigeria. Tell WhatsApp 081-427-5425, 091-526-91367, and send your emails to rollumsandluxury@gmail.com, Instagram rollumsandluxury, Facebook rollumsandluxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 091-259-21620 or send an email to resistandpartners.chambers@gmail.com.